So this is the 3 a.m. DUI series. This is video number 6 dealing with the Washington Department of Licensing Administrative Hearings. My name is Andrew Wheeler. I've been a DUI defense attorney now for the last 12 years and practicing criminal law in Southwest Washington for the last 14 years. Most clients that come in and talk to me have some sense of how the criminal process works, whether it be from television, law and order, things like that. But few folks have information on the civil portion of a DUI case. The first thing to understand when we go from the criminal side of the case to the civil side of the case is that the law changes. The criminal side of the case under the revised Code of Washington is the highest standard of evidence, called beyond a reasonable doubt. Whereas when we move to the administrative side, our evidence standards plummets. And it plummets down to what we call a preponderance standard. The best way to think of the preponderance standard is think about the scales in the produce section of the grocery store. Us, Department of Licensing. If those scales perfectly balance out at 50-50, we win. If they tip 1% towards 51% in the department's favor, 49% in our favor, we lose. Now, 49% doubt on a criminal case is an 8-minute acquittal. That's the fastest not guilty verdict I've ever gotten. 49% doubt civilly takes your driver's license. So the first thing we try to do when it comes to the Department of Licensing is avoid them. The client's first step that they have to do, and on this side of the case they're called the petitioner, is they have to request a hearing within 20 days of the incident. Again, not the first court appearance. We're talking about when either the breath test or the refusal took place. For folks that retain our firm, we do this mailing for them. We do it certified return receipt mail near the end of the process. Because once our hearing request goes out, certified return receipt mail, the burden shifts over to the Department of Licensing. And there's two things the Department of Licensing has to do. They have to have a hearing within 60 days of incident, and have to provide 10 days notice to the petitioner and the petitioner's attorney before that hearing. If the department fails to do either of those two things, it's called default. If default takes place, not only is the $375 refunded, but that portion of the case goes away. Now, let's say we're in the other, let's call it 89% of folks, where the Department of Licensing meets its time frames. They have sufficient notice and a hearing scheduled by the 60th day. Now, if folks have counsel, you can do a one-time continuance out to the 90th day. License remains valid, and the Department of Licensing can't change the game, meaning they can't come back and add paperwork or recheck boxes or find new witnesses. Everything pretty much stays the same. Now, I want to deal with one thing, and that's a warning letter that you're likely to receive within the first 10 to 20 days. This warning letter tells the client you will be suspended on day 60. And as I always tell my folks, it's one of the more poorly written letters I've seen. Because 3 paragraphs later it says, hey, to prevent this suspension, make sure you request a hearing. So again, that's a warning letter that will come out. As long as the hearing request goes in, the license remains valid. It can push out even past the 60th day. So let's talk about the mechanisms of the hearing. There are 5 hearing issues in the state of Washington. And I tell my folks to think about them like you would the doors in their house. Number 1 is your front door, number 5 is your back door. To take your driver's license, the hearings officer needs to move through those 5 doors. At each one of the doors, the hearings officer is going to have evidence, they're going to hear testimony, and in our case, they're probably going to read some suppression motions. At each one of the doors, the hearings officer is going to do that balancing test we talked about. If the test comes up 51% or more in the department's favor, the door will unlock and the hearings officer can walk to the next door. It does not matter where we stop the hearing, meaning there's no better win at door number 1 or door number 5. It just matters that the hearings officer cannot walk through all 5 of those doors. So what are the doors? Door number 1 comes from case law, and that is that the Department of Licensing has to evidence a valid stop. This is the only door that it's the department's burden exclusively, meaning the petitioner doesn't have to say, here's why the stop wasn't valid. Instead, the department has to evidence why it was. Door number 2 is reasonable grounds. This is all the evidence the officer gathers from the time of the initial stop through the arrest. Door number 3 is that a valid arrest does take place. And oftentimes we divide this into sections looking at the constitutionality of each part of the investigation. The 4th door is the implied consent warning. This is the door that not only has to evidence the petitioner made a knowing and intelligent decision, but also looks at whether or not the warning itself was relayed to the petitioner accurately, and if they had questions, whether those questions were answered by the officer. Finally, the last door is whether a valid breath test took place, and or if a valid refusal was secured by the officer. Again, the game plan here is that the Department of Licensing, at any one of those doors, if they can't prove their case by that preponderance standard, we win. Now, the decision from the Department of Licensing does not come out right away. The hearings officer has between 30 and 60 days to render his or her decision, and during that pendency, the license is still valid. When it comes to the hearings officer's decision, the hearings officer can only make one of two choices. There is no mitigation or negotiation. So in this sense, it means the hearings officer is either going to dismiss the action, which is great, or they're going to sustain the action. And if they do sustain the action, there are certain things that the client has to do fairly quickly. We're going to talk about that in a future video when we discuss ignition interlock licenses. And we're also going to talk about a petitioner's ability to appeal the administrative hearing to the Superior Court in the county where the incident took place. It's my hope that this video today has provided you some value when it comes to the Department of Licensing hearings, and I'd love if you reached out to me with any questions or concerns you may have in the future. Thank you.